As federal law is, there are certain restrictions and requirements that needed to be made in order to begin purchasing land. One of those is that the nation and district is authorized to purchase land in any one or more of three counties: Pima County, Pinal County, and Maricopa County. As you know, the nation historically has always existed in all three of those counties. Also, that the replacement land has to be unincorporated land within one or more of those counties. So in 2003, the nation purchased 135 acres under the provisions of the Settlement Act, and that 135 acres is what's considered to be the West Valley, meaning in the vicinity of Glendale, Arizona, Peoria, Arizona, West Phoenix. And the nation has been working to have that land placed into trust under the Gila Bend Act, the Gila Bend Settlement Law. The nation is authorized to use that land for the same purposes that were intended for use in the destroyed land. In other words, whether or not the nation or the district wants to use that land for residential, for agriculture, for farming, for economic development, all of those uses that were intended for the destroyed land transferred into the replacement land. And so the nation and the district determined that they wanted to use this land to build a high-end casino resort facility. And in the law, it requires that the Department of Interior take that land into trust. It says it shall take the land into trust. It also says that the land shall be deemed a federal Indian reservation for all intended purposes. And so part of the challenge, part of what we have been addressing is about 5.5 years of court action. Eventually, when the Department of Interior didn't make the decision to finalize the land into trust, the nation ended up taking the Department of Interior to court, which forced them to make the decision they know they needed to make. So once they made the determination that they were going to move and finalize the land into trust, they're required in the Federal Register to publish their intent. Once that that notice was published in the Federal Register, then litigation, then court actions began. Folks that were opposing the department's decision began to file legal challenges, challenging that the Department of Interior does not have the right to take this land into trust, among several other legal arguments. Gila River Indian community eventually filed lawsuit against the department and against the nation, challenging that the Gila Bend Act is not a land settlement act. That if we're allowed to build this facility, we're going to violate the state compact that we have with the state, that we're going to violate the Indian Gaming Regulatory Act, and that there was some promise that was made by the nation during the time of negotiating the current compact, that the nation agreed or promised that it would not game in the Phoenix metropolitan area. Well,
excuse me. So that means Gila River understood the intent of that land use plan that was before the land was taken into trust?
Well, there's no doubt in our mind that Gila River, both Gila River and Salt River, knew that the nation had this Land Replacement Act, and knew by that the nation had the ability to create an economic development project on any of the replacement land, and knew that the nation was intending to build, had eventually publicly noticed that it intended to build a high-end casino resort on this property. So they knew in advance. But essentially what's happening is that eventually Salt River joined in opposition, and for the most recent years, both Gila River and Salt River have been the primary opponents to the nation's effort. And they've argued in court. The court has ruled on all the issues that they've raised opposing us. The court ruled that this is in fact a land settlement. That was something that the Gila and Salt were saying, that our Gila Bend Act is not a land settlement. The court ruled yes, it is a land settlement. They argued that we're going to violate the state compact. The courts ruled that the compact authorizes the nation to establish a facility. They argued that we're going to violate the Indian Gaming Regulatory Act. The court ruled that this is not a violation of the Indian Gaming Regulatory Act, that the land is in fact eligible for gaming purposes, which means the nation can place a casino on any of the replacement land, and that they ruled that there was no promise, there was no agreement. In fact, during a number of the court proceedings, the judge looked at the Gila River and Salt River attorneys and asked them, you know, if this agreement, if this promise was so important to the Gila River and the Salt River, why isn't it not in the compact? You know, the compact language, there's language in the compact that says that the contents of the compact is the entirety of the compact, and that any side agreements, any promises, any contracts aside from the compact are illegal.
Well, tell us about the compact now. The compact is an agreement between the gaming tribes and the state, and what does it say? Well,
it says a lot of things. It basically sets out the legal parameters of what a tribe can do in establishing a Class 3, a casino-style gaming operation. But if we go back and we look at the 1988 Indian Gaming and Regulatory Act, it's that law that authorized tribes nationally to establish Class 3 gaming operations as long as the tribe, as long as the state in which the tribe is located authorizes Class 3 gaming. So early on, when the nation wanted to sign its first compact with the state of Arizona, and the compact essentially is an agreement. It says what we agree to do as far as putting up a casino, and it tells what the state can do as far as overseeing the tribe's gaming operation. And so what ended up happening is eventually the state said, no, tribes, we're not going to authorize you to establish casino games because the state of Arizona does not authorize Class 3 gaming. The tribes, in fact, Tono O'odham, Pasquayaqui, and White Mountain challenged the state's position on that, and basically took this legal position and said that state of Arizona, you do authorize Class 3 gaming, and you authorize it in the form of the state lottery. There's no difference between buying a $1 lottery ticket and winning a lot of money than putting $1 in a slot machine and possibly winning a lot of money. So at that time, before we had our first state compact, that issue was raised, and the tribes prevailed. The tribes, the federal mediator in that case, former Chief Justice Gordon, who mediated between the state and the tribes, agreed and said, this state, you do authorize Class 3 gaming. Therefore, that authorized the tribes to begin to negotiate compacts, or in other words, agreements with the state to set up their Class 3 gaming operations.
Now, the opposition for the tribes' West Valley project is primarily from two tribes, and why is it that they're the only ones, fighting this?
Well, as we have been litigating this issue, we've had there have been 16 major decisions that have been made in favor of the Department of Interior and or in favor of the Tono O'odham Nation. 13 of those decisions are decisions by the Federal District Court out of Phoenix, and a decision out of the Federal Court in Washington, D.C., and the Ninth Circuit Court of Appeals. Basically, what the court has done is it's listened to all the opposition argument, and it is primarily Gila River and Salt River that are challenging the tribe's ability to do this, and have ruled in favor of the nation and or the Department of Interior. The 3 administrative decisions are administrative decisions that the Department of Interior has made in favor of the nation. And so what we see happening is that eventually the Gila River and the Salt River realize that they're not winning their legal arguments, their legal positions on the way our land and water settlement law is written. So their effort now is to change that law. They want to change our land and water settlement, which is the Gila Bend Indian Land and Indian Land Replacement Act, by having Congress change the provision that we can use the replacement land in the Phoenix metropolitan area for this economic development project. Basically what we see happening in that effort is that they're really just trying to protect their market. They don't want another tribe coming into their market. Right now they have a monopoly on the casino patrons in that metropolitan area, that they don't want our tribe to come in and have that competition with them. That's basically what I see they're trying to do, is protect their monopoly on gaming in the Phoenix metropolitan area.
So do you see an end to this battle?
Well, I see an end because we broke ground. The courts have ruled in the nation's favor. We're constructing a temporary, or an interim facility, as it's called, which is a permanent structure. We hope to be open within the year of this gaming facility. We will begin constructing the entire project soon after we get this interim facility up and running, which will house the slot machines and begin to generate revenue for the nation, so that way we can also continue to build the rest of the project. We've got a $400 million project that is eventually going to be built with a high-end hotel attached to it. We've had some opposition from the city of Glendale. Over the course of the last 2 or 3 elections, the makeup of the Glendale City Council has changed. We now have 6 of the 7 Glendale City Council members that support this project, that have been opposing the federal bills that have been introduced, and one member of that Glendale City Council that still opposes us. Most if not all of the cities in the West Valley have either passed resolutions supporting the nation and the project, and or have signed letters of support. So basically you've got all of the West Valley and the surrounding communities where we have at least 70% support of the voters in the West Valley that have gone on record and saying, we support this project, we need this project, we want the economic benefits that this project is going to bring to the West Valley. And it's really the East Valley tribes, the Gila River and the Salt River, and the East Valley cities, Scottsdale, Tempe, those folks that see the benefits of those East Valley casinos, that don't want to see the West Valley benefit from the nation's project.
So what benefits for the nation do you see as from the income?
Well, I mean, it's obviously going to be a huge benefit, financial benefit. The revenues, the projected revenues are significant. Would be added revenue to the nation's general fund. The nation would begin to have the financial resources to address many of the issues that we already are challenged in addressing, but give us some resources, some financial resources to begin to address those issues that we haven't had much impact on, roads, infrastructure, housing, whatever the Legislative Council determines, or how it's going to determine the use of those revenues, are going to be huge and a huge benefit for this nation once this project is up and running and we begin to benefit. I was in a interview with the Arizona Republic reporters one time, and one of the reporters acknowledges, says, this is a gold mine for the nation. We know it is. The projected revenues are significant, but we're being challenged, and maybe that's part of why the 2 tribes see that. They see the benefits, they see the financial benefit they're reaping, and they don't want us to take any of that away from them.
Well, at the last council meeting in January, a couple of weeks ago, you were in the audience and you heard the concern of some of the tribal members through a petition about the per capita payment. What was your view of what happened?
Well, the revenues of the nation are really, if you look at the Constitution, the Legislative Council has the authority to determine the use, the purpose and the use of the revenues that the nation generates. So people, and I know that the Budget and Finance Committee is developing a way that the financial condition of the nation can be disclosed and protected, because one of the things that we want to make sure is that if anybody's going to receive the financial condition of the nation, that it must be nation's members and not non-members. What's going to happen with that information once it gets disclosed? And we don't want we don't have the non-members don't have the right to have any of that information. So people need to understand that the per cap fund, in fact, there is no specific fund titled per cap fund. There is a fund that is titled gaming savings, and it's that gaming savings fund that has been used in the past to fund the per cap. And if you go back and you look at how that per cap is generated through revenues coming in from the gaming enterprise. Ever since the recession, those revenues have decreased considerably. So that fund has not been generating the level of revenue that it was generating before 2008 when the recession didn't hit. So my belief is that once this added resource, this added revenue source with the West Valley project is developed and starts to generate revenue, that is going to definitely have a positive impact on the gaming savings fund that is the fund that has been used for the purposes of for issuing a per cap.
Okay. All right, last question. You're running again for the chairmanship of the Tohono Nation. This will be your third term if you win. So what have you learned and what are you projecting to do?
Well, Mel, the vice chairwoman and I agreed that we were gonna run again. We hope that we're going to be able to get reelected in a third term. We haven't really had the time to establish a definite answer to the question that you asked, other than when the campaign gets underway, which it hasn't. We'll be ready to disclose to the public what we want to be able to accomplish in a third term.
What do you consider your biggest accomplishments of the last two terms?
Well, I think that one of the biggest accomplishments has been to be able to develop a relationship between the two branches of government, primarily the legislative branch and the executive branch. I can recall coming into the office almost 8 years ago, and how much there was a division between the legislature and the executive. I knew that if we were going to get anything done, we needed to work together. We needed the legislature, and the legislature needed the executive branch. So the vice chairman, Isidro Lopez, the vice chairwoman, and I now have been working to continuously try and develop a close working relationship between the two branches. We don't agree always. We disagree. But we try to resolve those disagreements so that way we can continue to move forward. The other thing that I feel is a major accomplishment is that, before the recession, before the market crashed, the nation had a very, very positive projected revenue source. The casino was doing great. The businesses were the way that the nation generates the general revenue fund was doing really, really good. The economy crashed. Those revenues were not coming in the way they were coming in before 2008. We have dropped from a revenue source of about I can remember pre-Great Recession, $125 million a year to about $80 million a year. So we've had to make the adjustments to try and keep the nation up and running with a less amount of revenue to run the nation, and in a way to protect jobs. You know, one of the things that I knew I didn't want to do was to begin laying people off, cutting jobs. And so we've been able to cut elsewhere and keep the nation afloat. When I came into office almost 8 years ago, the nation was in a red. The nation was in a deficit. We have continued to be in the black since 2008. We have been continuously in the black, and I hope to be able to continue the nation in the black.
Okay. All right. Any last comments you want to add about maybe anything else that you're concerned about?
Well, you know, just to remind your viewers that you know, this West Valley Resort project has been extremely time consuming. It's been a major challenge for the nation. It's been a major challenge for my administration and for the Legislative Council. But what we need to remember is that this is a right. This is a right and a promise that was given to the nation by the passage of the Gila Bend Indian Land Replacement Act. But in addition to, and we have to protect that right, and we have to protect our sovereignty of the nation as well. But we also have to remember that the membership on the Gila Bend Indian Reservation, now San Lucie, those nation's members suffered tremendously when this flood forced them off of their reservation to the 40 acres that they're at right now. And that we have to protect not only our sovereignty and our right, but we have to protect the sovereignty and the rights of those members as well.